James. I'm with Viva Escrow, and today I have the pleasure of introducing, for the next 15 minutes or so, maybe even longer, we will be giving our attention to this distinguished panel of title reps, some of San Gabriel Valley's finest. So to my immediate right, we have Joe Haggerty. He's a sales account rep with Orange Coast Title. He's been in the business for about 14 years, and he's worked in many positions in the title companies, including customer service manager, and most recently, prior to going to sales and leaving, he was leaving a position as a junior title officer. He was our affiliate of the year in 2016 and even got the 2018 Good Neighbor Award. So please welcome Joe. And to his immediate right is Annie Fan. She's with Chicago Title, and she was our 2017 affiliate of the year. Welcome, Annie. In the middle here, we have Marcus Jacques, Senior Account Executive with Western Resources Title. He is 14 years in the business, and he actually just copywrote his second marketing curriculum. And again, it was affiliate of the year in 2013. Welcome, Marcus. And our last panelist is Nancy Chan with Lawyers Title. She's been a whopping 37 years in the title business. She's experienced in it all: residential, commercial, investment, hotels, subdivision, builders, services. And she was, can you guess, affiliate of the year back in 1989. Okay, so we'll go through some questions, and then at the end, we'll leave some room for you guys to ask your questions as well. So let's start with Joe. In California, which forms of vesting would effectively avoid the requirement of a probate hearing prior to a person passing on title in the event of a deceased owner?
So this is a good question for you guys to understand. Basically, you're not, as agents and title reps, we're not supposed to tell people how to hold title, but you do need to kind of recognize what could be required to close a transaction when you see how your client holds title. So, obviously we're going to tell you what's required, but knowing before you get into escrow is helpful. So the types of ownership where a co-owner passes away, joint tenancy, it immediately goes to the surviving joint tenant, community property with rights of survivorship. It should say that on there. That goes to the surviving spouse. And then there's a trust. There has been recently the transfer on death deed. You got to be careful with that because it's a new way of transferring title. The forms need to be filled out, properly, and we still don't know if that could ever bring up some type of underwriting situation at a title company where they maybe don't still ask you to go to probate or ask for further, information to prove that was a legitimate transfer. So those are the specific ways where holding title will avoid probate. If you're holding title as an individual, you should hold title as a trust if you want to avoid probate.
Thank you, Joe. And Annie, when the sellers are husband and wife as community property with rights of survivorship, but one of them passes away overseas, what requirement would that title require?
This is the questions I've been getting a lot lately, so I want to share with you. So first of all, title company is going to require the death affidavit of community properties. Then the deceased spouse, we will require the original death certificate. So for example, if John and Annie got married holding as a community property with the rights of survivorship, God forbid Annie went bye-bye, then what you need is to get the original death certificate from that country. Then you wanted to locate the court-appointed translator over here to translate that original death certificate from the local language into English. And that's what we need. Thank you.
Oh, thank you, Annie. Good to know. Let's skip over to Nancy real quick. Perfect. Why do title companies want uninsured deed affidavits?
This has been, the uninsured deed affidavit is when people transfer title after you purchase property and without title insurance. So it's called uninsured deed. It did not insure through a transaction. And I think me and some of these people here, we know that we never required any more documentation years ago. But the lawsuit, we're in the sue happy state. A lot of people that sign quitclaim or grantee after they purchase a property, even interfamily transfer, they coming back to sue the title company. They can say, well, I quitclaim to my wife or my brother because I was going to China and I wasn't going to be here for 10 years, whatever, so it's easier for them to take care of things. But if we sell them, let's say Marcus quitclaimed to me and I sold the property without Marcus' uninsured deed affidavit notarized, he can come back and sue the title company. Nancy and I had an agreement when we sell, she's supposed to give me half of my proceeds because I was going back to Africa for 5 years. That's where he's from, so. He's lighter than that, but I'm joking. But that's why the title company learned from different situations. And we're here, I think all of us will agree, title company needs to make money too, just like agents. And when there's a lawsuit like that, the attorney is not just going to file a claim, sue us. They're going to drag everybody into it. That includes the agent, the escrow, and everybody else. So we're trying to protect you and us, ourselves and escrows. So we want that uninsured deed notarized. So Marcus will have to sign another affidavit saying that I did on this day, the document recorded in 2017. That I granted to Nancy, and I will not ask for any financial and all that. I will not go to court, all that stuff. And he signs that and notarizes it, so then I can sell it. It's creating a lot of issues right now. That's why I want to bring it up. So that means if you're getting a listing, go ahead and order a property profile. Don't just go on your MRML as a real list and just get the computerized version. Then you'll find there's an uninsured deed. You know that these are going to be the requirement for all of us, not just me. I think all the title companies are doing that. So you will at least know ahead of time what you need to do before it goes to an escrow and you're running out of time and you can't find Marcus anymore. All right? So talk to one of us and find out what the requirements are. Thank you, Vanessa.
Thank you, Nancy. I get a lot of those lately.
And if we have time towards the end, I'll give you a horror story that will put your hair on end.
Well, let's go to you, Marcus. Let's say there's a divorce. Does divorce clear up judgments that may have been filed against the spouse who was removed from title?
Not necessarily. Not necessarily. I had a situation just recently where a gentleman is selling his home that he formerly had with his ex-wife. They bought it both together as single individuals, as joint tenants. And then they got married during the course of that, and then they got divorced during the course of that. Right when they were getting a divorce, they sought to divide the assets, and they did some research work, but they didn't find that there was a lien that was filed during their marriage, and it was filed in the wife's maiden name.
No.
So then the husband is awarded the home through the dissolution of the divorce, and he's now wanting to sell it. He sells the property. We open up a prelim, and lo and behold, there's a lien for $20,000 that got recorded right after the divorce. It was filed during the marriage, but it showed up in public record. All title companies go by the filing date of said judgment. So the day that it was entered in is when it hits and it attaches to the property. So now he had to deal with a $20,000 lien that was attached to the property. To add more challenge to the situation, he and his former wife are not on speaking terms. And it was a torrid divorce. So what wound up happening, and this was kind of out of the box thinking, I believe that there's power in the written word. So I suggested that the seller write everything that happened during the course of their divorce, explain how this never came up, and then he handed me over the letter, and I redacted it, and I brought it down to 3 paragraphs because he was giving us the Jerry Springer version of it, and and he sent it into the creditor. He sent it into the creditor, and they have released that $20,000. But you can imagine, this is again going back to what Nancy was saying. It's always good to get a property profile before when you're going in. And then if you have questions about the liens, I mean, when you have questions about those liens, those are things that need to be addressed right away. So time was on our hands because we got to it right on.
Okay, thank you, Marcus. Moving forward, we want to keep our answers relatively short. You have a lot of questions to go through. Let me go to Annie, because we were talking about divorce. So if John and Gloria got married and divorced in China, John quit claiming the house to Gloria, and now Gloria is selling the house. What requirement does title meet?
So first, because in China, there's no divorce decree. So then first of all, we will need some type of a written document stating, let's say, who gets what properties. And if, let's say, the ex, because the divorce got really bad and they weren't able to communicate or cannot be found, then we needed to actually let our underwriter to decide. So we would need all the requirements from, let's say, the ex-wife or whoever holds on title to prove that actually, she's the one getting that.
Okay. Anybody else have anything to add? Okay. All right, Joe. We are seeing a lot of this FinCEN Alta disclosure form. If you can tell us a little bit about it, and under what circumstances is that form required, and why are title companies requiring it before closing?
Okay, so this is something that's been around relatively since around 2015. We were not allowed to ever tell you anything about it legally, but we were told recently, I think a few months ago, that we can actually explain it to you now. And it's something that's been coming up very kind of rarely because of the circumstances, but you're going to see it come up even more now. So basically, anyone purchasing a property as an entity, a corporation, an LLC, a partnership, where the transaction is all cash or hard money, even a hard money loan, 100% hard money loan, it's right now it's set at over 300,000, and that's for Los Angeles County. So we know that's like almost every home is over 300,000, just about. So this is going to come up when you're purchasing a property with your clients, like maybe going to use it as a rental property, and these are 1 to 4 unit residential types only. So if they're buying it as a rental property, there's a good chance they may take it as an LLC. So this comes up, and all the title companies have to ask for this. It's it's federal law that we're required to ask for it, and basically it's a way for the government to monitor where funds are coming from, looking for illegal activity. Okay, so you're going to see this a lot, and right now it's in Southern California. It's only in San Diego and LA County, but it could spread because they had what's called geographic targeting. It could spread to other counties. It could change. So it's just the title companies will let you know when it's required in your transaction. So it's good to also let us know how your buyer is taking title as early as possible. When I see all cash transactions, I'm asking right away, how are they taking title? And also, we used to require it on irrevocable trusts, but I've been told that we don't need it anymore for that. So.
Okay. And I think it's in like 9 different counties, isn't it?
Yeah, there's other counties. It's like San Mateo, Santa Clara, San Francisco, or maybe one more in Northern California. And then it's in other states.
Thank you, Joe. Thank you. Okay, Marcus. What are private beneficiary deeds of trust, and what potential problems do they present on future closing?
Well, the deed of trust, as you know, is that instrument that banks use to secure a loan that they are insuring onto a property. So when a person takes out financing, they get a loan, and then what title companies do on behalf of the bank is they secure that loan with a deed of trust onto the title. What happens when that bank is not a bank, but it's a private beneficiary? There is a deed of trust that is drawn, and it is also secured to the property. Now, what happens down the line when you pay off a institutional or a bank loan and it's paid off, the bank will, by rote, write or record what is known as a substitution of trustee and full reconveyance. That's what they do by rote because they're a lending institution. But when it's mom and pop who have loaned money, or Uncle Joe who has loaned money to the people and has secured it with a deed of trust, that deed of trust may have been paid, or that loan may have been paid years ago, but guess what? When it was paid, the private beneficiary did not know that they needed to record a full reconveyance of the loan, and so it still appears on title and it's attached. Now, the problems that can arise is, okay, are they still alive? So that we can record that full reconveyance. If they aren't alive, did they convey that money from their trust? So we can get in touch with their heirs. And then if neither one of those two are apparent, then we will ask that the seller give some sort of proof that they paid that loan. Maybe they have a paid in full letter that they got during the course of that loan. And if that doesn't that isn't present itself, then what they have to do is they have to consult, the seller would have to consult a bond insurance company and purchase a bond at, I think, 1%, it depends on the amount, 1% of that loan, so that we can insure around it. So private beneficiary loans, it's very important to, if you know that somebody is getting like either a seller buyback or a seller carryback loan, or they're getting money from a relative by way of a private beneficiary deed of trust, it's always good to remind them that when that loan is paid, they're going to want to make sure that it gets fully reconveyed and removed from title.
Thank you, Marcus. And Joe? Yeah.
I just want to add to that as well. If you're the lender or you know the lender, someone recently doing that, make sure they keep copies of it, all the original stuff, because they need to also surrender the original promissory note, not a copy of it or anything like that, and that's going to be required by the title company as well as the zero demand, showing that it's paid off. Another thing is the bond company won't give a bond if they don't see proof that it's possibly paid, and if there's any litigation on the property, they also won't give you a bond. So the bond is not a for sure thing.
Yeah, and the bond, keep in mind, it's not necessarily just 1%. It could be, it's whatever's required and the risk.
They say it's based on the credit of the person applying for the bond.
Based on the credit and the amount of years. It could be like as far back as 1995, and it's still can
Right,
be, you know.
right. So something to think about and look into before it comes into escrow. Always a good idea. Nancy, we deal with power of attorneys a lot, and we need to submit them to title. How long is the power of attorney good for?
Well, let me first of all give you why there's a power of attorney. The fundamentals of the law, basically, I think understanding that will tell you, power of attorney is for somebody to use when you're temporarily absent. That is the foundation of this document, not for long-term use. So when there is a power of attorney, you have to look at the time. Title company usually would take 2 years. And some will be 1 year, but we'll usually go up to 2 years. So that's already very not temporary. So I think the title company is giving you guys a lot of leeway. So power attorney has to be done every 2 years. And it has to be notarized, and it has to have that, the special power attorney or the forms that the title company approve of. In the old days, we have what we call walkout forms, that we can go to the stationery store and get a power attorney. And in the power attorney, it's a blank. You type in whatever you want, because they don't know what you want to use it for. For real estate, title, loan purposes, you have to use our forms. And every title company has a website, the power attorney is on there. So if I have people that signs a listing and they don't communicate with their seller. The seller's leaving town, or last minute they have to go somewhere. You know, the communication is really important for the agents and your sellers or buyer. Because if they're leaving, you need that power attorney. Okay, so and a lot of times signing documents overseas is difficult. I had a client, a couple, they didn't tell their seller they're leaving on a cruise for the world cruise for 2 months. And they wrote a note for the son to take care of everything, and the agent didn't know about it. So that was really a tough deal. So power attorney is important, but it's for temporarily absent, not for long term. Okay, thank you.
I think it's good to add that it's not going to be, the title company is not going to look at it in questions of demise or incapacity.
Yeah.
And if I could add, just again, check with your title and your escrow company, because everyone's a little different, but the main thing is that it needs to be specific to the transaction. So it's not just a general one, and we need to typically turn in the original to the title company for review. Joe, let's go back to you. Why is it in some transactions that owners and title policies are required?
This is something to know for your clients, for your buyers or sellers to understand. We get asked a lot, you know, why do we need both the lender policy and the owner's policy when there's a loan? Obviously, if there's no loan, you want at least the owner's policy so that if a claim arises, you can file a claim. But some people are saying like, well, why do we need the owner's policy? We're already getting the, you know, or why do we need the lender's policy or vice versa? Well, the lender is definitely going to require this because the lender needs the policy to ensure that they have the proper positioning of their loan priority, and there's other reasons they may have a claim arise later. But if you only get that loan policy, which it is an option to only have a loan policy, and the only thing it will ensure you is that your name was put on the property, you were given title of the property, nothing else will be covered for you as the owner. So if a seller's telling you, hey, you don't need that owner's policy, it's probably because they don't want to pay for it or split the cost or however you're doing it. Don't accept that. Make sure your buyer has an owner's policy because they'll left to just have to sue or open litigation against the previous owner or the neighbors or whatever arises that could be a title claim. So do not avoid getting that owner's title policy.
Okay, anyone else? Annie, when title is under a trust, say mom's a trustee and she's in the hospital, she can't sign the papers. What requirements does the title company need to pass on title?
Okay, first of all, we need to review the trust. Then for the incapacitated issue, we will require 2 different doctors' letters, okay? Then we're gonna to pretty much review that. So the successor trustee will be able to execute all the documents on behalf of the trust. And then piggyback on the uninsured deed. How will you figure it out if your property has uninsured deed is you pull out the grantee on the left upper corner on the deed. Doesn't matter if it's a quick claim deed, grantee, if there's gonna be a title company's name on it on the left upper corner. If you don't see that, that means the party, they transfer the title, you know, they did it, maybe go to like recording office and record it by themselves. That's how you figure it out if it's uninsured deed or it's insured. And it's with no value.
Well, to piggyback on that, even though there's a title company's name on it, we do a lot of accommodation for people. It will say accommodation only. So there's two things, look for escrow number, a title order number, title company, and not the word accommodation. Yeah, and consideration, but quick claim deed, there's no consideration when they do the transaction. So look for the title order number, not the name, not the term accommodation. There should be title and escrow order number on it, okay?
Nancy, since you have the mic, I have another question for you.
Okay.
What is an easement?
Okay, I put a flyer out on everybody's, on the table. It describes easement, and I think it's really difficult for people to understand. But easement is a piece of land or part of a land that's given, granting to somebody else for a specific purpose. For example, an alley, a driveway, utility, those are all easements. So you have to specify the purpose. Okay, so the question will come up when you have like agents. I always think about what would the agent do when you see easements. If you know your client is going to tear down and build or remodel, whatever, you should always have the title company plot the easement. On that sheet, you'll see how we plot the easement with different colors. We'll specify where and with colors. Also, if you have a builder, you want to buy a vacant lot, all the easements should be plotted. At least they'll know where they cannot put structures on there. Right now in the San Gabriel Valley, one of the biggest problem that I run into is almost every month somebody calls me on a driveway easement, on a private easement for ingress and egress. And I hate to say this, a lot of people park on the driveway, the easement for in and out. And we see a lot of condos, which is a sign of that the condo is not well managed, that people park in front of their garages. That is totally not right, because the easement is for you to go in and out that driveway, not for you to park. Okay, so some of these things you need to know, that your client says, there's cars parking in the driveway, I'm gonna buy this, I can park another car in front of it because I have 3 cars. It is really, they can get the car towed. And I had a friend that parked in front of the girlfriend's garage one night. When he came out, the car was damaged, somebody ran into it. Insurance company wouldn't cover it because he parked where he was not supposed to park. Okay, so easements has a specific purpose, a specific area for somebody to use. Okay, so that's what it called easement. So the plot of easement is on the sheet. It's a little difficult to ask, but ask your title rep when you have a question on easement. If we can't get the answer, our engineering department will get the answer and where it is and how it is, and it's plotted on that sheet for example. Okay, thank you.
Just one thing to add to the easements. When you're looking at a prelim and you're trying to decide like who benefits the easement, the easements listed in Exhibit A, your legal description, those are the ones that benefit your subject property. The ones listed in Schedule B benefit another person or property.
Joe?
I'm gonna piggyback on that. So the sequence, how you get the easement plotted map is first, we issue the preliminary title report. So you cannot just, call in your title rep saying, hey, I need an easement plotted map. It doesn't work that way. So first you have to order the preliminary title report. When, like what Joe was saying, all the easements listed on the prelim, then the engineer, they're gonna plot the easement to create an easement map. So unfortunately, you cannot just call in to talk to your title rep and ask for the easement plotted map.
Give them time.
In some cases though, if it's like, not even just new, but definitely like a more recent development, often all the easements are shown on a tract map. So you can ask for a tract map and it'll show almost all the easements, but it's not a guarantee that all the easements are there.
Okay, so we have time for just one last question. Marcus, because you didn't get your third question. So what are just a couple items listed on the prelim that a buyer and buyer's agent should focus on and be concerned with?
For the buyer's perspective, there's a way of looking at the prelim. The first thing that you would want to look at is what kind of policy is the buyer getting. And you want to make sure that if it's a residential transaction, your buyer, the policy contemplated for title insurance is a homeowner's policy, because that has the most coverage, and I believe that it's the one that's required by car. So they have the most coverage. If it's a standard policy, you're going to want to question that with the title company, especially if it's being bought by an individual. Second, that the property that their persons are contemplating buying matches up to the legal description that is on the prelim. So in other words, they're buying a home and they think it's a single-family residence, but they see that the description is a condo. That's another thing that they're going to want to verify it. Then, looking at Schedule B, which is all the exceptions, if they're buying a home that has a large yard and they want to eventually build on it, that they understand where the easements are, as we just spoke about. Also, if there's Melrose that encumber that property, if they have Melrose taxes that they're going to be dealing with. And lastly, now more and more you're finding properties that have a HERO program agreement. So that'll be listed in there if the sellers are involved in a HERO program. So hopefully that was brief, to the point. In terms of the other liens that they have, they don't have to worry about those because those are what the sellers have to clear up before they.
So do we have time for questions from the audience? Not really, right? Okay. So we're going to wrap it up. We don't really have any time for questions from the audience, but these guys will be around afterwards. If you can, feel free to approach them after the meeting and give them your support. And if we can give them all a round of applause again.